My name is Alexis Ferracuti, and this is our first vlog, which is exciting and also kind of terrifying because now I'm speaking to you, and this is how I would speak to anybody that was in my office. So I think it's nice because it brings everybody a little bit closer to our office, but at the same time, it's scary on my end because now I'm being tape recorded and put on the internet. This week, my vlog is going to be about what to do after you get divorced. I think it's a lesser known area of practice for us. We actually do a lot of family law work, and we're actually expanding into taking more on of that kind of work. So that would mean child custody, divorce, grandparent visitation, what to do after you get divorced, how to handle some of your assets. So what I want to go through is just kind of the basic list of things you should think about after you've maybe completed already your dissolution agreement. But these are the things that maybe you might want to redo as you move forward on your life without your ex-spouse. The first thing would be, if you had a will before when you were married, after you get divorced, you're going to want to go back to that attorney or back to a new attorney to draft the will. We do in-house wills here for $100 flat fee for any will. What you do basically is you would come in, you would explain the situation. If you have children, you'll let us know that. If you have specific items that you want delegated out to others, you would let us know that. And we'll go ahead and put down all your real property that wasn't taken care of in the dissolution agreement. We'll go ahead and note that all out, and we'll draft a new will. That way it takes care of any mention of your ex-spouse that might have been in your old will. And if something were to happen, a week after the divorce decree, you're covered, your children are covered, your family is covered as to what you would want them to receive, and it doesn't go on the old wishes of an old will. The next thing you might want to think about is your 401k. I think a lot of people go after a divorce, they're so overwhelmed by either I just lost my house, or I have my house but I just lost my car, now I need to go get a new car, that they forget to think about some of the other things that they've already put their spouse's name on when they first got married, like a 401k, a pension, bank accounts, which I'm sure bank accounts generally are dissolved within the divorce agreement, but I would say that you should probably still consider maybe checking accounts or trust accounts or other CDs that you set up for your children. That may be something that you want to have it in a trust for your children instead of both of your names on that account. If you can come to an agreement with your ex-spouse to do that, or if that's already been covered in your divorce decree, obviously it's nothing you have to worry about. But on a 401k, for example, that would be a beneficiary plan. So what you're going to want to do is contact whoever your agent is, or if it's through your employer or if it's through an insurance company, you'll want to contact them. Speak with them about what your next steps are. How do I change my beneficiary? Do I need to submit a form? Do I need to come in and speak to you in person and sign a form? Do I need to have my signature witnessed by a notary public? If you need a notary public for any of these documents, our office also has those here, and they are available for free. We're all happy to help out. A notary public is just somebody who witnesses you signing the document to prove that you were the one who actually signed the document in question, and submitted your approval for that document to be processed. The next thing would be to think about any power of attorneys you might have. There's a power of attorney for property and a power of attorney for healthcare, which I talked about in my last vlog. If you had your ex-spouse as your power of attorney for either of those things, at this point that's obviously something you may want to reconsider. Maybe you're best friends and maybe it just didn't work out as a marriage, so maybe you want to keep them as your POA. But quite frankly, most people probably aren't in that situation and will want to change their POA to somebody different. That may be a parent, it may be a sibling, it may be a cousin, an uncle, an aunt, whoever it may be. They just have to be over 18 years of age. And if you have any questions about how to decide who your next power of attorney is, you can go back to my blog from 2 weeks ago and see it there. In terms of other things you may want to think about, life insurance. I know several people have different plans. Sometimes an employer will offer a $15,000 plan, and then sometimes they'll go out and get an additional plan for maybe $60,000. So when you've talked to your employer about your 401k being changed or your pension being changed, the beneficiary in those things, you may want to also talk to them about any life insurance that's through them. But then don't forget, if you have supplemental policies, you're also going to want to contact your insurance agent to change some of those things. Likewise, if you had joint insurance, that's something I'm sure that's going to be addressed through the divorce decree, but that's something you want to consider as well. Other than that, I think that basically the only thing left that's major that I could think of is making sure that you get your power of attorney for healthcare to your doctor's office with your new power of attorney on it. I think it's really important to have that set out, especially if you have children and you want to make sure that they are taken care of if something were to happen, or somebody is there to make your decisions for you if something were to happen for you. You'll also want to make sure that if for some reason your spouse has passed on, your ex-spouse has passed on even, you'll want to make sure you have a guardian set up that in the event that something happens to you, those children are, set to be cared for if they are minor children. If they're pretty close to the age of majority, I don't know that it's something you necessarily might consider, but it is something if they're younger, you may want to consider appointing a guardian or having a guardian set out within your will. You can do that as well. You can say that I have minor children, I would like the minor children to be cared for by, upon approval from the state of Illinois or from the courts of Illinois, from the county of, wherever you may live, whether it's LaSalle, whether it's Cook, whether it's, down in Bloomington. You'll want to make sure that that county is the one that approves it, but you'll want to have it set up so that your kids have someone to turn to if something happens. I think that those are the major things that you want to think about, and I think maybe some people forget. Obviously, a divorce is a stressful time. In our office, like I said, every client, and I think I've said this in the past, every client in our office is family. So regardless of what you're going through, regardless of what's happening to you, I treat you the same as I would treat my uncle, my aunt, my cousin, my mom, or my dad, whether or not they would both agree that's a good thing. When you come in, we'll try to help you through the situation from beginning to end as best we can and with as much empathy and understanding as possible. We sympathize that it's a difficult time and are happy to help you emotionally and also physically through the transition. We thank you for your business again and look forward to working with you in the future.